Thank you, Mr. Chairman. Question, and Patrick, either one of you. Okay, so when I was reading into this seemed to have stemmed from the incident in Clackamas County, if I remember right. And so I read as much as I could about that, and then I did some study of the last, well, I went back to 1913, I think, trying to find another case of outside of the Old West days of 1885, somebody brandishing a firearm in a courtroom. So we're talking about a concealed weapon, right, of which nobody would know unless what? How did they find out that this fellow in Clackamas County was packing?
Mr. Chair, Representative Post, I don't know all the specifics about the Clackamas situation. I don't know if he was open carrying or not. Certainly, we have a number of counties and some cities that are facing fiscal distress, and so oftentimes the security isn't there to screen everybody like there is in a lot of different circuit courts. But certainly, again, this is another tool that we hope our local communities can choose to implement if they would like. As far as enforcement, that's a very good question of whether or not I don't think everybody's going to start getting frisked when they go into court or anything like that. But I'm sure our courts will probably post signs if they chose to implement the law.
Follow. I guess that's my point. So we're going to have to go to some sort of enforcement. This bill's worthless if it doesn't have enforcement, because right now a judge can say, stand on your head and whistle Dixie. The judge can say anything. He can ban anything. She can ban anything. It's already part of our law. And so we're really kind of, to me, addressing a problem that doesn't exist, because there was a situation in Clackamas and nobody would have known the man was carrying a firearm unless there was a pat down or a metal detector or something that he got through. And I read the story in the case and I didn't see anything. He bragged that he had one, is what I understand. We don't even know that he had one. So that's my fear from this. This is another situation where I don't know what the problem is.
Clackamas County does have a metal detector.
Okay, so there you go.
Because they wouldn't let me
already.
They wouldn't let me in the courtroom with a small knife.
Right, so there
not in the
have to be
Justice Court.
Oh, not in Justice Court. Okay.
Okay. But, so there would still have to be enforcement. Either way, there would have to be enforcement. How do you know?
Yeah.
So just by putting a sign up saying, "Hey, you can't have a weapon," it's a concealed handgun license.
I did talk to one justice of the peace who said he'd had people come into his courtroom with open carry, which he found to be intimidating to somebody else. So.
Yep. And that would be absolutely different. I could see something in here that would say that addresses that.
Well, this says you can't have a gun in the courtroom, so. But, okay.
You're going to have to start patting people down.
Further questions or not?
A comment, if I may, Chair Barker. I'm aware of a second case also in Clackamas County. Clackamas County is how we roll. The one that came up was in the Justice Court in Clackamas County, and I thought, although I could be wrong, that it was an open carry situation. I could be wrong. The other one I recall was back in 2009. I used to represent the city of Damascus. A very unpleasant experience. I don't recommend it to anyone. And there was an open carry situation in the Damascus Municipal Court, I recall, which I don't even think exists anymore. But I do recall it being a situation now.
But again, could not the judge have just said, "I'm sorry, no, you can't have that here"?
But I think
it's already law.
The municipal court in Damascus, I believe it is.
The judge has the ability to say that in any court, anywhere, at any time.
I don't believe that's accurate in municipal court anymore.
Chair Barker.
That's what this bill would do, I think.
Chair Barker, Representative Post, and Representative Barton, that is correct. Under the current law, no, that judge would not have the authority to do that. However, Senate Bill 385 would allow the judge to do that. That's what this bill does.
Right now, judges do not have the ability
in municipal and
in any court.
No, in circuit court you can't go in. In the circuit court you can't, but in municipal or justice courts, they can't prohibit you from.
So, Chair Barker and Representative Post, the current bill, ORS 166360, as is written right now, prohibits somebody from carrying such a firearm in a circuit court, a court of appeals, the Supreme Court, or the Oregon Tax Court. So in any of those instances, yes, a judge would be able to prohibit it, and in fact, it would be a violation of the criminal code. However, this bill allows a municipal court judge, a justice of the peace court judge, a juvenile court judge to have that same protection, to make it a violation of the criminal code for somebody to do that. So there is a difference between whether or not this is going to be a crime and whether or not it's a local court rule. For example, Representative Greenlick mentioned that Multnomah County doesn't allow pocket knives of any sort, but whether or not it would be a crime to carry that in there is another matter altogether.
Okay.
Chair, if I may, Chair Barker, members of the committee, I must, if I heard your counsel correctly, I must disagree slightly. I believe there is another prohibition in the statute that would prohibit a local government from prohibiting concealed carry in any public building in another statute. So the same way, we have the same restriction the state does, whereas the state can't prohibit CWP carry in its public buildings. Neither can we. The only exception is in a circuit court, and we're simply asking for the same authority that the circuit court judges have.
Okay, thank you very much.
Thank you.
Kevin Sterrett, please.
Members of the committee, for the record, Kevin Sterrett with Oregon Firearms Federation. Unfortunately, I think you've made a mistake here. We litigated this very issue, and Representative Post is exactly right. The judges have the authority to ban guns in municipal and justice courts, and this is not speculation on my part. The lawsuit was in Damascus, of all places, Jim Leuenberger versus Damascus. We took it to the circuit court, and the circuit court said, yes, municipal courts and justice courts are not specifically labeled in the statute as the courts that are included in this, but a judge is still a judge, and he can make whatever rule he wants and hold you in contempt if you don't obey it. I personally interacted with this in the Canby court myself when my wife was subpoenaed to testify against some gang members. I knew that the court didn't have a blanket prohibition, but the judge had a prohibition. I asked the judge if he would allow me to protect my wife in the courtroom. He said no. That resulted in the following lawsuit. As it turns out, that these same people who my wife was due to testify against next appearance in court fought with each other and the police, so I don't think my concerns were unjustified. But the fact is that the judges are judges. And while some good changes were made from the original statute, this bill is entirely unnecessary, and all of this could have been settled with an email to the judges who apparently don't know what their powers are. And it's a little concerning to me that we would have all these judges come and testify who didn't know that this was the case. And that is, as I said, this has already been litigated. We brought that up on the Senate side. They did make some changes so that the rooms in question wouldn't be off limits all the time. They recently moved the municipal court in my town from the chambers where the city hall was to a room in the police station. My police station currently has a sign posted saying no firearms, which they have no authority to do, which the chief told me he had no authority to do and didn't take it down. But on page 2 of the bill, where it describes what a local court facility is, it says a building in which a justice court, municipal court, probate court conducts business. And you can't get into the municipal court in the Canby police station without walking through the hallways you would need to talk to anybody else in there. And I wonder if they would consider that a place where they conduct business. But the fact is that they have that power now. And if you want to look it up, as I said, it's been adjudicated and it's in the law.
So if they could already do this,
yes,
what would the bill hurt to pass? I mean, what if we pass this bill?
I think that's a great question. I think one of the problems, one of my concerns, of course, is the ambiguity in that language. But I suppose that we can take that position any time, and there's half a dozen bills that have gone through the Senate Judiciary Committee, going through here, that I think have accomplished absolutely nothing because they were already existing law. So they didn't hurt, but I have no idea why we spend so much time on things that are already law because people are ignorant of them. So no, because it's not going to hurt, but I don't see where it was worth all our time on this.
Maybe it would clarify. Okay, thank you very much for your testimony.